Hello everyone. Welcome to the Public International Law course. We will begin with Chapter 1, The Nature and Development of International Law. In this chapter, we will talk about the definition and the basis of international law. Then we will look into the historical development of international law, and we will conclude with international law and municipal law. Let's start with the definition of international law. The majority of the earlier standard works on international law define it as a system of composed legal rules and principles binding upon civilized nations only in their mutual relations. This definition, however, doesn't embody all the attributes of today's international law. Law is something process-oriented and dynamic. This is equally true for international law. Like all living laws, international law is also not static. We can say that it is constantly developing and restructured in the process of its application to new situations. That is why international law sometimes changes in a qualitative way. Let's have a look at the modern definition of international law. Today, it is generally recognized that public international organizations and individuals are also endowed with rights and duties under international law. Modern international law is set to govern the relations not only among states, but also between states and other subjects of international law. After the definitions, we should talk about the nature of international law. There have always been some talks about the nature of international law, whether it is true law or not. Critics of international law deny its legal character and do not consider it as a true law. But whether international law is true law depends on how one defines law and evaluates its objects. John Austin was a legal philosopher who was a strong critic of international law. In fact, he was also the chief protagonist of the view that international law is not true law. Austin's opposition to international law stems from his definition of law. According to him, law is the command of the sovereign and it should be backed by a superior political authority. There is also another question that is frequently asked about this topic. Is international law weak law? Nevertheless, international law has been termed as weak law. Critics of international law argue that it differs remarkably from municipal law in many respects. These can be the absence of an elected legislature to frame laws, the absence of an independent third-party dispute settlement mechanism, and the lack of effective sanctions to punish those states who break the rules. Apart from what we have just talked about, there is also the matter of the international law not always being enforceable. Hans Kelsen, who gives primacy to state law, holds that international law cannot be equated with state law, because he argues that behind the true law stands the state. There must be an institution that is strong enough to enforce the law against perpetrators. However, Kelsen later acknowledged the authority of international law. He pointed out that in some societies, like the international society, enforcement of law can be accomplished through the application of the principle of self-help. In his opinion, international law is true law. This is because it provides sanctions such as reprisals, war, and the use of force. It also makes resorting to such sanctions lawful and legitimate as countermeasures against a legal wrong, but unlawful and illegitimate in all other cases. Let's continue with the basis of international law. Jurists have long struggled to identify the basis of obligation in international law. There are two main schools of thought about this foundation. These are the naturalist school and the positivist school. According to the jurists of the naturalist school, the law of nature is the foundation of all law. As such, international law is a part of the law of nature. There is also the positivist school. The theory known as positivism or the consent theory emphasizes the consensual nature of international law. Now that we know the meanings and the basis of international law, we can talk about the historical development of international law. Modern international law has its origin in the 15th and 16th centuries following the disintegration of the Holy Roman Empire. It grew out of the customary practices of European states in their mutual intercourse. Naturally, it was affected by the political theories prevalent in Europe at the time. In fact, international law was a byproduct of the gradual increase in the power of nation-states, such that it replaced the European feudal political and economic system. Nevertheless, throughout its course of development, international law remained predominantly European in character. In addition, in the earlier stages it was confined only to the relations among Christian states. Development of modern international law can be studied under two distinct headings: development during the classical period and development since World War I. Before we end our course, let's quickly talk about the relationship between international law and municipal law. Municipal courts have to face situations calling for the application of the rules of international law. Similarly, an international tribunal may need to determine the precise status of a rule of municipal law if the case before the tribunal has some connotations of municipal law. If there is a conflict between municipal law and international law, the court has to come to a decision whether international law takes precedence over municipal law or vice versa. Besides, the question of primacy before a municipal court is determined mainly by the constitutional law of the state. So, this is the end of our program for Chapter 1 of the Public International Law course. Goodbye and see you in our next program, Chapter 2.